Okay, thank you. Um, so on the next slide, I'm going to begin with a very quick overview of how planning decisions are made. Some of you may know this already, but I think it's important that we cover the basics first. So generally speaking, when a developer wants to build something new or change the use of something, they need to apply to the council for planning permission. The council decides whether to grant or refuse planning permission, and legislation requires them to make their decision in accordance with the development plan unless material considerations indicate otherwise. And there are some broader legal considerations to consider as well, and that's going to be the sort of main structure of what we run through today. So when I say the council makes the decision, it's important to understand exactly which part of the council we mean. So you have the council planning officers, who are the council's member of staff, and they have the technical planning knowledge. They will do the initial negotiation with the developer, the initial assessment of the application, and they will prepare a report giving detailed analysis of the application and giving a recommendation. However, they do not make the actual decision on the application. It is the council members the councillors who sit on the planning committee, who make the ultimate decision. So even if the officers, the technical experts recommend grant, it is within the power of the democratically elected committee members to refuse planning permission. And then there's also a third group, which is your local ward councillors, who hopefully are willing to listen to your concerns and advocate on your behalf. But how ward councillors approach these things massively varies from case to case. Sometimes they'll be very proactive and you'll feel like they're part of your campaign. Sometimes they'll be quite defensive of the council, and quite resistant to engaging with you. And sometimes they just won't be bothered at all. But if you make it's a big enough political issue, if you campaign hard enough, they will probably feel like they can't ignore it, and they will be more likely to engage. So a big part of this is making it clear to them why they should care, and hopefully bringing them on board to advocate for you. So when you're referring to the council, it's important you're clear on whether you mean the planning officers, the committee members, or the ward councillors. They're different stakeholders and they have very different perspectives in the planning process. Often the different aspects will have their own little battles against each other. Often, for example, there's a power struggle that goes on between the officers and the committee members. The planning officers want to control the process and they want to ensure the committee members follow their recommendation. And I've found that officers are generally less interested in engaging with community concerns. I think they often feel that they know best and that they've done all the work, and they're often intent on pushing their agenda through. So sometimes it's not the most fruitful to try and engage with them. We always try, but sometimes we don't get very far. So sometimes it's the committee members who are more easy to have an open conversation with and effect change through. So sometimes it can be that you're campaigning for months and months and raising these points with officers, trying to get some sort of publicity, getting nowhere. And then it's only when you finally get to the planning committee and you deliver your speech to the committee members that they finally show an interest. And all of a sudden, the planning officers and the developer are suddenly interested in negotiating with you because they're suddenly desperate to get approval from the committee members. So next slide, please, Sarah. As I said, the council needs to make its decision in accordance with the development plan unless material considerations indicate otherwise. So your starting point is the development plan, but what do we actually mean by that? Confusingly, it's actually two different documents in London. So it's number one, it's the London plan, and then it's also the local plan for whatever borough you're in. So for Elephant and Castle, it's the Southwark Plan. For Shepherd's Bush Market, it's Hammersmith and Fulham local plan. So it's very important that you have a look at both of them and look for key policies relating to your specific situation. I appreciate, I don't know if you've tried to look at them, they're very big, unruly technical documents and they can feel quite impossible to navigate. My advice is to look at the contents page and look at the section headings, and that will give you a steer of the sections that might be relevant to you. If you have a specific application that's going on right now that is affecting your market, please feel free to reach out to me and I'd be happy to help you find the key policies and give you a bit of a steer. A question from Joseph: is it legal for council officers to develop a close relationship with developers? And what about committee members? That's a very good question. And the reality is council officers will have a very close relationship with the developers. And it can genuinely sometimes feel like the officers are almost like presenting this as if it's their application or defending it as if it's their application. They will have negotiated with the developer behind closed doors in the what's called the pre-application. Before they've properly submitted the application, they'll be sort of sounding it out with officers and getting an idea of what they'll be willing to accept. And the sad reality is often the officers are willing to accept something that's sort of below policy compliance, and we'll get on to talking about that in a second. It can often feel very unfair, and it can feel that you're kind of there's a conversation that's gone on, an agreement that's been made before the community's been involved. There's nothing inherently wrong about that, and it would be incredibly hard to challenge that, which is a big part of why in our campaigning we don't get very far with officers a lot of the time, and we have to direct our campaigning towards the ward councillors and the committee members instead, and that is often the more fruitful conversation. If the developer, on the other hand, was speaking to the committee members, that would be a bit more of a risky situation for them, and that might be prone to a legal challenge. The committee members need to make sure they're not seen to have predetermined the application or made their minds up in advance or be closed off to anything. Generally, the developers won't speak to the committee members in advance. They're able to deliver a presentation at the committee, as are we, but they will generally not speak to the committee members in advance. Could you tell us a bit about the influence of political parties on the decision making? So, yeah, the sort of political overlay is the officers are not party political, they're not elected. The committee members will be made up of councillors from across the borough. They will be most likely a majority of whatever political party your borough is. And, you often find that it is the minority members who are probably more willing to be outspoken because they might see it as a bit of a point scoring opportunity against the majority party. So, for example, in Southwark, we have majority Labour with a few Lib Dem councillors sitting on the committees. Sometimes you find that it's the Lib Dem minority councillors who are more willing to speak up because they're less inclined to follow the sort of council status quo. The Labour officers might be inclined to show that the council's doing a good job. I don't want to speak, for everyone here. There's many Labour councillors who do a great job campaigning for us and with us. But you might find that they do think slightly along party lines. So that is definitely something to consider. And the MP can get involved. They might be able to speak at the committee. They're another route that you might try and channel with your campaigning. But the MP themselves doesn't actually have a direct voice in this decision-making process. They can have a soft power, but no direct decision-making. There's another layer of politics here that I'm not going to get into today, but the GLA has a power sometimes to call in the decision and make it themselves. The Secretary of State also, the Secretary of State for Housing, Communities and Local Government also has the power to call in some decisions and make it themselves. That's very rare, and that would only happen in sort of big, high-profile cases. And the current trend right now is that they are both sort of pushing through consents despite communities sort of objecting. So probably not the most fruitful avenue to consider, but it's always on the table. And if you're looking at that, I'd be happy to talk to you about that in more detail. Can campaigns only engage with committee members, though a representation at the committee meeting, or contact them outside of this? That is a very good question. So for the similar reasons I've discussed, committee members are going to not want to engage too much in discussions. But what we've tended to do is send them a crib sheet, 1 page max. But the day before or a few days before, you can find out who they are on the agenda for the committee. And we just say, hey, we're representing the community campaign. We're going to be speaking. Here's our concerns in advance. Here's what we're going to be saying in our speech. Please read it in advance, get an idea in advance of what our concerns are. And we encourage some questions from you. And it's hard to tell if it works. They generally don't respond, but sometimes we found that they are asking questions based on those. So, just as in the same way that officers get a sort of advanced opportunity to send their report and give their recommendation, we see that as our opportunity to give our views in advance and make sure they see where the community is coming from, so they're not hearing it for the first time on the night. Imogen says, councillors on our planning committee mostly refuse to engage with community because of the quasi-legal status of the committee. So yeah, that's what I'm getting at. They're potentially scared to be seen to be predetermining it. But there's nothing stopping you. It's completely legitimate for you to have one-way traffic of you sending your concerns to them. I hope they read it. Um, Keep it short. They're not going to want to engage with much. Um, there is a bit of an issue sometimes with officers not really engaging with with committee members not really engaging with the detail, and sometimes that leads to a position where they're just going to follow what the officers say. So keep it short, grab their attention, don't hound them, try not to annoy them, keep them on side, but by all means, raise your concerns with them in advance. The other thing I wanted to say on the development plan, the London plan and your local plan, these change every few years. And the GLA and the councils, as a part of that process of preparing a new plan, need to carry out a public consultation. So be on the lookout to see if your local plan is changing and make sure you get your voice heard to fight for stronger policy protections. And it's really powerful if you can give an example of where the current policy isn't good enough and has let you down or let your market down, and let vital pieces of London's cultural, social, economic infrastructure let that down. Um, you might be able to influence policy. The sad reality is a lot of people don't know that that consultation is happening. The developers know it's happening, and they will very much engage with that process, push for site allocations that kind of pave the way for a development, or push for policies that are more favourable to them. And often the community voice isn't that loud in that process. So be on the lookout. And it's well timed because the London plan consultation is happening right now, and it's happening, the initial stage is happening, I think, until late June. So have a look and get involved. On the next slide, I'm going to look at some specific policies relating to markets. So you can get your voice heard if you think these don't go far enough or they are good and they need to be retained in the new London plan. Strongly encourage you to engage in that process. So yes, the one on screen, policy E9 of the London plan. I think this is probably the most important policy in there relating to retention of markets and retention of retail. It's quite a long policy. I'm not going to run through the whole thing. It's worth reading in full, but what I'd see is the key proposal here is on screen. Development proposals should prevent the loss of retail and related facilities that provide essential convenience and specialist shopping. It also says development proposals should support London's markets in their full variety, including street markets, covered markets, specialist and farmers markets, complementing other measures to improve their management, enhance their offer, and contribute to local identity and the vitality of town centres and the central activity zone. So as you can see, there's some fairly strong policy support there to protect retail and to protect markets in particular. So you could say if you are losing your market to a development, you could argue that the application fails to meet this policy because it does not prevent the loss of retail and related facilities. And those facilities provide essential convenience and specialist shopping. Obviously, you will need to demonstrate why your market is an essential convenience and specialist shopping. That shouldn't be too hard, knowing the markets that you're from and supporting. But importantly, you'll also have to show how any proposed replacement retail fails to adequately replace what is already there. So, a developer might turn around and say, well, yours is essential convenience, specialist shopping, but so is ours. So the loss of yours is made up for by ours. And then you'll have to get into a discussion of showing why, I imagine theirs is going to be some generic retail that isn't essential convenience and doesn't meet the sort of specialist needs of the area. And I'll talk about that in a bit more detail in a second. Similarly, sorry, you can just go back to the second part there. Subsection 5, it offers protection, but it also, in that language, it sort of paves the way for development as well, because it speaks about improvement and enhancement of markets. And that's going to be language that developers are going to try and cling on to and interpret as justifying potentially displacement of existing markets if they're replacing it with a new one. Again, you'll have to show how the proposals are not an enhancement and they fail to contribute to local identity. That's probably the key phrase you want to cling on to there. So yes, next slide. I just wanted to quickly run through some other London plan policies that might be relevant. It's worth reading it in full always, but here's just a sort of snapshot of a few. GG5, growing a good economy, that talks about having a diverse economy and having sufficient employment space in various areas across London. Policy SD6, town centre and high streets, that talks about having varied and resilient town centres and complementing local character. So you can tell the story of how your market is a big part of that local character. D5, inclusive design. That speaks about collaborating with local communities, creating spaces that facilitate social interaction and inclusion. S1, developing London's social infrastructure. That talks about ensuring the needs of London's diverse communities, making sure they're met, and that social infrastructure is inclusive. So, as you can probably tell from a lot of that language, it's quite woolly, it's quite subjective, it's easily sort of gamed by the developer and maybe the planning officers to show how what's being provided, the new development meets those concerns. Your job is to counter that narrative and show how, in reality, the diverse needs are better met by the existing market, and at the very least, uh, the existing traders and the existing culture needs to be protected. If a new development is going to be ahead, your market needs to be a key part of it. So on the next slide, I just wanted to give you a snapshot of the Southwark Plan. Like I said, it's going to vary borough to borough. I do not have a detailed knowledge of each borough's local plan, but I thought it might be helpful to give you a snapshot of some of the relevant policies in Southwark. So we've got one here, P31, that's all about affordable workspace, has a strong beginning policy of retaining small and independent businesses and trying to provide space in the new development for them that is affordable and suitable, and also the delivery of 10% of all retail of all office space should be affordable office space, but it also speaks to potentially affordable retail and affordable cultural uses. There's a further policy on small shops, which is specifically includes markets. That's about physically small shops, and the policy defines it to include markets. And P33 says if you cannot keep the existing businesses on site, you need to give them relocation support. And if you are bringing them back to the site, you need to give them temporary relocation during the construction. So quite a detailed, robust policy. The reality is lots of other boroughs will have not quite as strong policy as this, but it's always worth having a look and seeing what you've got. You never know. You could have a policy that's incredibly strong for whatever reason. So on the next slide, I've given you an overview of some of the policies, probably the most relevant ones, and now I wanted to quickly talk about how to apply them in practice. A really important point to note is that not every single policy has to be fully complied with. The council only needs to look at the development plan as a whole and assess each policy, if it's compliant or not compliant. You need to look at the balance of harms and benefits as a whole and look at it sort of holistically. So if you find one breach, it's not a silver bullet. It doesn't mean you can stop the whole thing. But if it's a strongly worded policy like the ones we've just seen, the first one I read out, which sort of spoke in terms of development should, and it was quite prescriptive, that gives you quite strong grounds to try and demand that policy is complied with. In our experience, councils often overlook key details or key aspects of policy wording, or is too willing to accept the developer's perspective. So it's very valuable for you as a community to raise specific policy breaches, and the closer, more specific wording you can identify and the stronger wording you can identify, the better. You can use that to give your view, kind of make the committee members afraid that this application is in fact a breach of policy and demand more from the developer. So, for example, we worked with Latin Elephant and the community campaign in relation to the Borough Triangle application by Berkeley Homes in Elephant Castle, which affected the Mercato Metropolitano traders. Despite this quite strong policies in the Southwark Plan that I read out, the developer was originally offering zero protection to the individual traders, but due to our intervention, we managed to campaign and successfully get the creation of a temporary market that some of the traders could work in during the construction period, and also a £200,000 support package for traders who would be relocating off site. It still had issues, it still wasn't perfect, but better than where we started. So you really can achieve something if you point out a policy and campaign for it. So on the next slide, please, Sarah. As I said, the development plan is your starting point, but the council also needs to consider material considerations and whether they indicate something different to what the policy says. So policy is not the end of the story. You need to also consider material considerations. They are not clearly defined. It's quite a loose concept. It can cover lots of things. It has to be related to planning, and it has to generally be a public concern rather than a private concern. I tried to think of some potential material considerations that would be relevant to markets, and I've got some on screen there. So the social, cultural, or historic importance of a market. I should have said on the previous slide as well. It referenced heritage policy. So if your market is designated as a heritage asset, either as a listed one or a local listing, that will give you some policy protection, and it also might help you paint this material consideration social picture of the sort of cultural importance of the market or the historical importance. Look at the socio-economic context of the area as well. Does the market provide specialist goods that serve a particular demographic? Is it particularly affordable to local people? Is it goods that they can't get elsewhere, or is it stuff they can't afford elsewhere? So, for example, you've probably all seen that the Aylsham Centre in Peckham is subject to an application for redevelopment right now. We've highlighted that the independent shops on site serve the local West African population, and we think that their displacement hasn't been properly considered, and that should serve as material consideration. The points either against the application or at least for stronger protection for those businesses. We've also identified the fact that, given the large amount of deprivation in Peckham, which is borne out in the evidence, the markets provide more affordable goods, and that loss is going to be felt by that community. And we think that's not been properly considered. So we're trying to bring that into the equation as a material consideration as well. Often the council officer's starting point is going to be quite a restrictive view on what is a material consideration. They're not going to take that expansive view. So it's our job as the community to kind of broaden the scope and bring in those more nuanced social pictures. So as I've said there on the slide, it's an opportunity for storytelling beyond policy. And that is something that you're campaigning with ward councillors. They might want to run with that. If you show they'll want to be seen to be fighting for the local community, hopefully. You can make it a kind of local political issue and bring those stories in. So on the next slide, as I mentioned at the start, there are also some specific legal duties beyond that initial test of the development plan and material considerations that the council will have to consider. A key one that I'm going to mention today is the public sector equality duty, which is section 149 of the Equality Act 2010. That requires the council to have due regard to certain equalities concerns and to mitigate the negative impacts of those potential equalities concerns. So the duty relates to certain so-called protected characteristics as defined in the legislation, and that includes race. And the guidance suggested that this notion of race includes nationality, ethnicity, and place of origin. And indirectly, it can include things like language barriers and inability to sort of access certain information. And the other protected characteristics that might be relevant: age, gender, disability, and there are a few others as well. Importantly, class or socioeconomic status isn't included as a protected characteristic, but you may be able to show, the intersectionality of the protected characteristics that I have mentioned and how they interplay with class or socioeconomic status. And it's also worth checking. A lot of local authorities have chosen to effectively treat socioeconomic status as a protected characteristic. So while it's not part of the legal test, it sort of effectively becomes part of the story that way. So I know in Southwark, and I believe in Lewisham as well, they've both chosen to treat socioeconomic status effectively as a protected characteristic. So that's something to consider.
Yeah, there's a couple of questions in the chat.
Yeah, sure. Under what circumstances do businesses have to be relocated? So that would be, I suppose, are you thinking about the Southwark Plan?
Yeah, that was in response to the Southwark Plan.
Yeah. So the Southwark Plan defines small businesses and independent businesses. Those are the definitions. Small businesses is about having 50 employees or less, and independent businesses is about having 3 locations or less. So if you're on site as a small or independent business and you're going to be displaced, there is this sort of initial policy push to retain you on site and make it affordable or suitable. And the developer should do that unless they can demonstrate for some reason why that's not possible. The policy, if it's not possible, the policy doesn't say they have to actively relocate you, but what they have to do is support you with that relocation. And, we get into a detailed negotiation and an argument quite a lot about what that means. The policy is clear that it's not going to be covering rent in a new place or actively, 100% finding you a new location. But what we've, through the work of Latin Elephant as well, have kind of got that to mean is, in the case of the Borough Triangle that I mentioned, it was about 10K per trader to find professional support services to help you find a new place, lawyers to help you enter into a new lease, the cost of fit out, the cost of moving, potentially any lost costs during that process. And also the developer had to sort of actively prepare a database to find potential opportunities. So, it's limited, it's not perfect, but it's some help. And part of our once you do open the door to that negotiation, you can try and push for as much as possible. And if you do feel like you have got that kind of political pressure there, you can try and, squeeze as much out of it as you possibly can.
And does it matter? Sorry, does it matter who the landlord was on the original, like whether it was publicly owned land or if it's already by developer?
I think the policy doesn't draw that distinction, but we're looking at that right now actually in relation to there's a marina in Southwark that's council owned and it's being redeveloped. And we're trying to put a bit of political pressure on. We're highlighting the fact that the council as landowner, hopefully, we would hope would go the extra mile and do a particularly good job of that. Unfortunately, their starting position was very poor and not policy compliant. So you can use a bit of political pressure there, but in strict sort of legal policy terms, there isn't extra entitlement if it's council owned land. But as you can see, this is it. Planning is a weird world where law and policy collide. So there's a lot of subjectivity and nuance, and you can use the policy to open the door to a conversation. And then once that's open, you can, tell your story and try and get as much as possible to try and make it work. And as I've said again, you can use the ward councillors to try and, reach out and demand that more is done. Often the discussion at committee will go beyond policy and will go into more social considerations about what the council wants to do and what sort of protection they want to offer. And you'd be amazed at what a developer will be willing to compromise on last minute when they feel like they're going to lose their planning application. All of a sudden, a lot more money is suddenly being coughed up. I've seen, tens of thousands of pounds suddenly appear on the night to help relocate businesses or local charities, just because they feel like if that's going to get them the permission on the night, they're willing to just to pay that cost. There's another question: can it be argued by those affected that if council planning officers have engaged in detailed discussions with developers and not with local people, how can the officers be seen as neutral or impartial when presenting their views? Isn't the officer views going to be biased by the work they have put in? I think this is a conversation that comes up a lot, and we've already touched on it. One thing to be clear on, and I probably should have mentioned this, during the application process, there has to be some form of consultation by the developer of the local community. However, it's not very prescriptive what level of consultation has to happen. And often the sad reality is that consultation will be quite poor. They will have to notify those with a legal interest on the site. So if your market is being affected, they should notify you. Question mark whether they will actually notify individual traders if they've just got some sort of license of relationship. Legally, they may not have to notify you. You would hope they would anyway. But as I said, there is a consultation window, which is at least 21 days, in reality going to be much longer, where anyone can give their views, what's known as an objection on the planning portal on the council website. And the council officers have to consider them when they prepare their report, and they have to summarize them in their report. So a big part of our campaigning, and I think I'll touch on that in a minute, is to get people to object, make those objections detailed, relate to policy, relate to material considerations, bring in those hard policy points, but also the storytelling and the social sort of emotive side of things, get as many people as possible to object, get a strong community campaign together that creates that political pressure that kind of counteracts that relationship between the officer and the developer. But in terms of arguing lack of neutrality or impartiality, it is incredibly difficult. It is a tall hurdle. The officers are allowed to give their view, and if they have negotiated with the developer, chances are they think they have reached a position that they think is acceptable. Um, if if the officer's view hasn't properly engaged with policy, hasn't properly grappled with concerns, and then members have effectively not truly understood the policy position or haven't truly understood all the material considerations at play, you might be able to consider a judicial review. That is all about process. So it's all about have all of the legal considerations and all the policies been properly understood and interpreted correctly. It's not about the balancing exercise. The officers and then ultimately the members are afforded a lot of discretion in how they balance things. So if they have understood, if they've interpreted the policy correctly, and if they have considered every relevant consideration, it's they're afforded basically all complete discretion in how to balance those different competing interests. So you can't judicial review because you think they haven't understood the importance of the market if they've engaged with the policy, but then decided that other things, the benefits outweigh that harm. So judicial review, very limited in scope. It's based on legal process, but it is possible to bring a judicial review if you think key bits of policy have been overlooked or key considerations have been overlooked. And the reality is often, as I've said, the detail of the policy isn't always engaged with. Sometimes things are overlooked. And sometimes officers will give an incomplete view or a potentially incorrect interpretation of policy. So it's definitely something to consider, but I think we need to be pragmatic that it is limited how successful a legal challenge on that basis would be. Hopefully that answers your question. I can't see if you, so hopefully that answers your question. Let me know if not. So back to public sector equality duty. I was saying how you might be able to bring in socioeconomic status either because the council have elected to treat it as a protected characteristic or through indirect ways through the intersectionality of class, socioeconomic status, and other protected characteristics. So the usual process for meeting this public sector equality duty is the preparation of an equalities impact assessment. But the weird thing that happens in the world of planning is that it's the developer who prepares this and the council then approves it. So the duty is on the council when they're making their decision to comply with this duty, but they rely on the impact assessment prepared by the developer. And, as you might expect, the developer is effectively marking their own homework here. So unsurprisingly, they tend to overlook the potential negative impacts and they focus on the purported equalities benefits, the benefits. So often what you see is it seems like another opportunity to sort of sell the scheme. And they'll say, look, we're delivering affordable housing that will help the local community. We're making our site, even if they're delivering a low amount of affordable housing. Or they'll say, we're making it wheelchair accessible, so it supports it has positive impacts in terms of disability. But usually it's a very unnuanced, oversimplistic view. And what they tend to overlook is the reality of the people who live, work, or use the site, what their protected characteristics are, and what the direct impacts of those individuals are. And that is something that we try and bring into the conversation and try and highlight as part of this duty. So important that when you're engaging with an application, you read that equalities impact assessment and you highlight aspects that you think are missing and elements of mitigation that you think need to be brought into the picture. With markets specifically, often they will serve specific demographics, and you should make clear, tell that story, show what goods and services are offered to meet certain demographics and how they will be missed and how they're not being provided in the new development, and follow that up with demands of what you expect to see as mitigation. So that would be protection for those traders or some sort of alternative provision for those communities in new community space or something to mitigate that harm. On to the next slide, how we can make the community voice heard. So as I've tried to show throughout this, community voice is an essential part of this process. It's key to highlight certain policy breaches, material considerations that might be being overlooked, and equalities impacts that might be being overlooked or understated. The planning process before the community gets involved can feel very cold and dry and quite inaccessible. It sort of boils down these stories of people and in places to uh, numbers and cold bits of paper. And it's our job to remind the council this is all about real communities and real places and real people. And I think it's important to show that you're not against development per se. Annoyingly, the rhetoric has been boiled down to this NIMBY YIMBY dichotomy, which I don't think truly exists. You need to show that you want development. You just want development that complies with policy and delivers sufficient benefits for the existing community, and it brings the community along with it and protects essential inherent parts of the culture and the community that need protecting. So there's lots of different opportunities to get your voice heard, and as I've said on the screen, bring it to life with these first-hand stories. We've kind of touched on this already, but I'll run through it again. First step is submitting objections. They will be read by the officer when they prepare their report. Make them strongly worded, but based on policy, based on material considerations, based on qualities impacts, and based on that emotive storytelling. Campaign, raise awareness, get further objections in, make this a political issue, make this something that all eyes are watching. The committee members want to make sure the public that are electing them, and make sure they know what they want and make sure they're thinking about that. They'll always have their eye on the elections and making sure that the voters are happy. So you can use that to make sure that development actually is serving the community. As we said, we write to committee members a short crib sheet, just giving them advance notice of our concerns to make sure they're aware and thinking about questions to ask the developer in advance. And finally, as we've touched on, registering to speak at the committee. Be careful, each council has its own rules about this. In Southwark, for example, you have to register the day before, you have to email a certain email address. All objectors only have 3 minutes to speak. If there are two different objectors, you have to split that time between you. So it can be very rushed. What you're allowed to do is encourage the members to ask further questions. So what we tend to do is use that 3 minutes to kind of put the issues on the table, maybe point out other members of the team that we have with us and encourage further questioning to elaborate and expand on those points and give everyone in the team a chance to speak. Different boroughs will have different rules, so make sure you understand yours and you know how it all works. The developer will have a chance to speak as well. Any people in support will have a chance to speak. Ward councillors will have a chance to speak. So as we've said, it's important to speak with them, get them on side, hopefully get them to speak on your behalf. And what you can do is coordinate your speeches so they're covering some issues, you're covering other issues, and make sure you're not duplicating points and you're covering a broad range. So that is my overview. That is the timeline. That is how I think you can be most effective. I see there is another question in the chat. Planning applications include a mountain of documents that can overwhelm campaigners' capacity. Also, don't believe that the officers get on top of these. If permission is granted, is it permission for all these plans or the officer's report plus the final section 106? Yeah, I agree. It can be hundreds of PDF documents on the planning portal, and each of them can be hundreds of pages long. What I would say is there are key documents to read, the planning statement being one of them. The DAS, Design and Access Statement, is another key document. And then, as I've said, the Equalities Impact Assessment is important. And then, reading the titles, you might see one that's particularly important to you. It might be it might be some sort of statement about existing businesses or something like that. So look out for them. I know it feels impenetrable, and it truly is. Reach out to us. We can at least give you a steer on what documents to read. And if we have capacity, we can help you navigate them. there is often key bits of information hiding in those documents. It's like the equalities impact assessment in that the developer is presenting all of their own information, they're marking their own homework, they're giving a pretty, I would say, one-sided picture, and it takes a pretty keen eye to read between the lines and see what's missing in the documents or what is implicitly lacking in the documents. If we have capacity, we can help you with that process, and that can often be quite fruitful to kind of tease out the key issues, and then we can use that to campaign and raise awareness and kind of put some pressure on the developer to improve things. I can't say to what extent the officers are really engaging with the detail. I'm What I know is that in reality, the committee members aren't going to be engaging with every single one of those documents. They will be relying on the officer's assessment. So that is why it's powerful, and that is one of the key services the law centre can provide is that technical review of those documents. We've got experience navigating them. We can kind of prepare our own view of that, and we can present that with the community to the officers and to the committee members. And that is a key channel that we can provide. In terms of advice, if we don't have capacity, it is incredibly hard, and I know it feels like a completely impenetrable system. I think if you can campaign effectively to split up the task, divide it between you, don't kill yourself reading every single document. Focus on the key ones, and over time you hopefully get a knack for it. But there's unfortunately no easy way around that difficult task. The final question there: if permission is granted, is it permission for all these plans, or the officer's report plus the final Section 106 agreement? So what will technically be granted permission is there is a description of development which will appear in the planning statement, and it will appear on the planning portal. It's that kind of front end wording. That is technically what is being granted planning permission. The planning permission will also refer to certain documents, certain plans, and they will be part of those hundreds of plans you see on the planning portal. If they are listed in the planning permission, they become part of the planning permission. So what's contained in those plans will be part of the planning permission. The permission will also have conditions on it, and those conditions might refer to documents, might refer to further documents that have to be submitted. They also become part of the permission as well. Imogen's referred to something called a Section 106 agreement. That is basically a contract between the developer and the council, and it regulates the development. So if they do get planning permission, it will be subject to that 106 agreement, which gets negotiated between council and the developer, and it will say various different things around timings of what needs to be built when. For example, what level of affordable housing needs to be built, what type of affordable housing, when it needs to be delivered. In terms of markets, it might be at what point the market traders are allowed to be displaced. There might be a certain certain moment in the timeline. They will probably have to submit some sort of strategy for what sort of support is offered to them. The various relocation supports that we've already mentioned, the detail of that will all be set out in this Section 106 agreement. And one thing that we can offer there is a detailed review of that agreement. And hopefully, councils don't always share the draft before it is formally entered into. But if they do, we can help you read that and highlight concerns, drafting issues, moments where it's not giving enough protection, and hopefully fight for better provisions in that agreement. And as I said before, if we feel that Section 106 doesn't deliver on the promises made to the committee or the things that the committee relied on when they granted permission, that would be potential grounds for a legal challenge by judicial review. I hope that answers your question. So if we can open it up more generally, if there are any other questions.